I want to call to order the September 10th meeting of the Marshall County Board of Zoning Appeals. First item of the business is a roll call of members.
Mr. Bennett.
Here.
Mr. Hostetler.
Here.
Mr. Kephart.
Here.
Ms. Meares.
Here.
Mr. Gustafson.
Here. Next item is a review of the August 13th meeting. Anybody read the minutes?
We don't have minutes on the agenda this evening. We'll put the minutes for the August meeting on your October meeting. So that would not be next.
Okay. We'll pass by that. Okay, the first case, 24 BZA 28, Sheila Tinkle. Sheila here, come on up.
Mr. President, Garrett Tharp was unable to make it this evening, so members of his family are here in attendance on his behalf as the applicant.
Okay. You can grab a chair from over there if you would like and pull it over there. And if you would have a seat, each of you state your name and address for the record, please.
Sheila Tinkle, 5981 Quince Road, Plymouth.
Hey, ma'am.
Taylor Tharp, 901 Ferndale Street, Plymouth.
And you, sir?
Charles Tharp, 9505 Collins Drive, Plymouth.
Thank you. Ty?
All right, we have a tabled request by Garrett Tharp to allow a property split that does not meet the 1-to-3 width to depth ratio and allow for 2 units per 5-acre density located at 5981 Quincy Road, Plymouth, Indiana, Polk Township, zoned A1. So here's the subject property with the William Bradley tile running in from the west and the Emma Mishler ditch, both county regulated drains through the property. And they're wanting to split said property through the middle. One of the items of interest that was brought up last time during the meeting was the frontage along the road, as well as the estimated distance between the western property line and the west-hand side of the ditch, because there's a 75-foot easement for ditch maintenance on either side of that ditch. So you can begin to do math and create the residual where structures could be located. Here's some aerial photography showing what the property looks like, as well as some pictures from our previous meeting, looking up and down the road, the ditch itself, and as it goes through the property. The procedure for this is the Board of Zoning Appeals reviews and makes the final decision on this case based upon the findings of fact as defined in state statute. For the analysis, the applicant is seeking to subdivide their family property that is 5 acres with a ditch, Emma Mishler, that runs relatively through the middle of it. Plans to divide the property relatively in line with the ditch. The lots would be more or less 140 and 180 foot by 660 foot, more plus or minus, and it would be at a density of 2 units per 5 acres. The county ditch and tile both have associated setbacks and will need to meet the other associated development standards. This would include any drainage board approval if there is a proposed development within the ditch and tile setbacks. For the findings of public health, safety, and welfare, use and value and strict application are taken into consideration. For finding number 1, the approval should not be injurious to the public health, safety, and general welfare. For finding number 2, the use and value of adjacent property should not be impacted in a substantially adverse manner. And for finding number 3, the strict application of the zoning ordinance would not permit the proposal, but the property's natural features lead to a difficulty in developing the property as one piece. So for recommendation based on the information provided and reviewed by the Technical Review Committee, staff and TRC would recommend approval of the proposed variance. For additional information, there was no additional information provided. The location of that that the applicant has indicated where they would like to build is in the larger section on the western proposed parcel and is approximately 225 foot. Now it is up for board determination.
Anything you would like to add?
No.
You did a good job.
Questions?
Do you know where you're gonna build on that other lot?
On the north end, at the widest point there. Right?
So you're gonna put a,
About where the white square or rectangle is on the picture.
Okay.
If you're seeing the same picture,
Yep,
in that general area.
okay. So you're gonna put a bridge and a driveway through there and build back there?
No, there's a drive that runs on the west side of the ditch. That, there used to be a mobile home back there for my grandma, and there's a current drive on the west side of the ditch.
Okay.
So they wouldn't have to
That
go
goes to,
across.
about back to that the white rectangle.
And the entrance is on the main road there, Quince Road?
It's on the 6th Road. The address that used to be there on that mobile home was 16020,
6th Road.
6th Road.
So there's a driveway coming off 6th Road to that, where the trailer used to be?
Yes.
Okay, that's what I was
Yep.
going.
Yeah, off of 6th Road.
Okay.
Yep.
So Ty, what's the minimum lot size?
Minimum lot size in the A1 district is 1 acre.
Well, it says the agricultural district shall have a maximum residential density of 1 home per 5 acres, right?
That's a density regulation, not a lot size regulation.
So I can.
1 unit per 5 acres is a density regulation. 1 acre is the minimum lot size.
So anybody can build on 1 acre in Marshall County now?
They have been for quite some time, yes.
I didn't know that.
And wasn't there, I think Garrett looked up, and wasn't there several properties within a mile that was less than 3 acres?
He said there were several properties that were less than the 5 acres.
I went to the book, I didn't see that.
There,
It's always been 5 acres, I don't know.
no, 5 acres is a density regulation in which if you were to subdivide property, you would need 10 acres in order to get 2 units. That's why they're
So
here.
anybody can come in and get a permit on 1 acre, separate it from another piece and build on it?
Yes, sir. If you had 10 acres today and you walked in with a split application to split 1 acre off that 10, creating 1 and 9, or anything between that and 5 and 5, you could split that property, provided you met all the split regulations.
I didn't know they could do that.
That,
And
So how long is it, this is before you?
ever since before I got here.
it's, I was on the committee when we drew this up, and it was always 5 acres has been the minimum lot size.
Other than, I think you had an
They had
exception.
5 acres and it was 260 feet, and I think they shortened the width of the lot. up.
210 lot frontage would be a 210 by 207, gives you a few square foot over 43,560, which is 1 acre.
Yeah, but I thought
And-
from 1980-something, you could take 2 1-acre lots off your
Yeah,
bigger
if you sold
lot.
your farm, you could sell.
Right, since
2 acre lots for
2007, yeah,
65.
they adjusted the split calculation and everything associated with the parent size tract. And it's
Wow.
been a minimum lot size is the second development standard underneath the density regulation in which you're referencing.
We're not upset with you, we're both. We're
I've been
confused.
involved. You were in agreement with something. I saw you shaking your head. What are you in agreement with?
No, I just agree with how he's interpreting the regulations.
Thank you. That's what I thought.
Because I have seen other parcels.
We've approved.
Actually, my family did one about 10 years ago.
Yeah.
So according to the zoning ordinance as referenced online, the minimum lot area per residential unit is 5 acres, minimum lot area is 1 acre, minimum lot width 210 foot, maximum lot width to depth ratio 1 to 3, 3 times the lot width. Minimum lot frontage is 50 foot, and then it goes into setbacks.
So the guy raising your hand, we're gonna have a public where you can come up and talk. I know, but we're gonna
call
open
that.
up to the public
It's not
soon.
open to the public yet.
This is completely catching me off guard. I've never, so I can split 1 acre off of I can split 1 acre parcels off my entire farm and sell them?
I think a lot of the reasoning was, this is how we used it. We had a 10-acre farm, had an old farmhouse on it, and we were doing some estate planning, and we carved off, and this was before, the property had 3 homes on it. Because again, those homes were built before Marshall County had zoning, the homes were built in the 70s. So you had 3 homes on 1 parcel, which you can't do anymore. So we were doing some estate planning. We said, well, how do we want to fix this? Two homes were, one was my dad's, one was my grandfather's, and the other one was a rental. And we said, well, how can we fix this? We came to the county, we carved off the 1 acre one, the rental became 1 acre. That only left us with 9, but we wanted to try to create 2 separate ones, so we actually had to come for a variance, and we created, I think, a 4 and a 5. You know, so we took that 10 acres and went 4, 5, and 1. So, I know it's, I mean, it's,
I guess this is catching me off guard here. It's always been 5 acres. I don't know.
Move we open up public.
All right.
I'll second that.
Motion made, second, open public hearing. Those in favor say aye. Aye. Opposed, nay. Motion carried. Public hearing is now open. Anybody here to speak in favor of his request? Come on up. To that table there, please. If you would state your name and address for the record.
I'm Jan Wagoner. I live at 5731 Quince Road.
Okay. Go ahead.
I met Garrett last week. He is an Indiana State Police officer. He had just gotten off duty from the toll road. Really well-versed in this whole issue. He's impassioned about growing up there, seeing grandma there, being on the property, has a lot of sentiment about being there. I feel like he'll keep the property up and do a good job with it. And I don't have a problem with it at all. I live just 3 houses down, pretty close. Go by the property all the time. I think it'll be absolutely fine, no problem.
Okay. Anybody else?
Thank you.
Come on up.
You can go.
Okay.
You have a seat, and if you'd state your name and address for the record, please.
Steve Listenberger, 5731 Quince Road. I've talked with the neighbors probably half a mile, 3/4 mile of the other residents, which another one is here today, in favor of allowing them to build. No complaints from anybody on Quince Road, probably 3/4 of a mile up from the building site that you're discussing. To me, it's not very often that you can weigh in on who a neighbor might be, and you know, boy, it's just a big throw of the dice. Garrett, public safety personnel, great family, know them now maybe 25, 30 years, a lot of members of the family. They would actually be an asset to the neighborhood. And again, I've talked to the other people that actually border right on that property. They have no problem with it. And as well as we have another neighbor that is probably the second, as far as Quince Road goes, bordering on them. And then we're the next property.
Okay. Thank you.
Yeah, good family, good thing.
Anybody else?
Thank you.
Come on up.
Hey, didn't see you there.
He would say-
Mark Wolver, 5825 Quince Road.
Okay. You can sit down if you'd like.
Okay. I don't have any problem with people moving in, but our water is what I'm concerned with. When I first moved there like 45 years ago, it was 5 acres then. And the people that lived on the corner where Tinkle's house is now, with Bob Smith, he told me that he got a variance because his house and all that was too close to the water. So we just don't want another variance where the septic system is too close to the water.
Okay.
Because, I mean, there's a lot of fish in the water, it's not polluted.
Was there a septic system with the trailer there?
Yes.
Okay.
So that's our main concern,
Okay.
is, you know, keeping the water from getting polluted. And where would the septic system go? It has to be 75 feet from the ditch,
Yeah, they'd have to work that out
at
with
least, you know.
the drainage board and with the health
They
department.
have to approve that, right? That's not our call here. Okay.
All right, thank
All
you.
right.
Thank you.
Anybody else speaking in favor? you have a seat and state your name and address for the record.
My name's Tim Swihart. I live in the house just to the left of the blue line there. And I don't have any problems with them moving in there. I mean, we get a lot of the field, we get a lot of mosquitoes because, you know, it's hard to keep it mowed. And she's by herself. I would appreciate it, keeping it mowed down.
Okay. Thanks.
Thank you.
Anybody else to speak in favor?
Andrea Smalls Reed, 5721 Quince Road. Been in the area since 2002. Just recently got to know Sheila. My kids have helped her out, but driving past the house many times a day for many, many years. They've done a great job always keeping up. Know the family a little bit from church. Great family. I trust they'll do the right thing. I don't have any problem with them building there, just because I know that they'll keep it up. They're good. They're nice family, and would love to have more of their family closer to Sheila. I think it'd be good for her and for the family.
Okay, thank you.
Thank you.
Anybody else to speak in favor? Anybody speak against? Any correspondence?
No, sir.
Motion to close?
So moved.
Do I have a second?
Wait a minute. I think I was against too.
Okay, that's fine. We understood.
Yeah.
If you'd state your name and address for record, please.
Elizabeth Woolever, 5825 North Quince Road,
Okay,
same as that good-looking guy over there. And really, I'm not opposed, because I love Sheila Tinkle and I love the family, but we are the Woolevers, an older couple, neighbors to the north next door on Quince Road to Sheila Tinkle. We sure don't want to cause any trouble, yet cannot help thinking that two properties on such a small plot of land may cause septic tank problems for the Emma Mishler ditch that runs through both Tinkle and Woolever and everybody else's properties. Not only would wildlife living in and drinking from the Emma Mishler ditch be in danger from septic tanks too close to it, but hunters seeking to feed their families by putting a buck in the freezer could also be in trouble eating deer meat from a deer drinking from a polluted ditch, or as we like to call it, a creek. Also, one of the young Tharp men has hopes, along with his wife, of eventually starting a family, something we hope goes well for them. But how safe would it be raising little kids who could, God forbid, tumble down a steep bank into the Emma Mitchler ditch? Plus, drivers on both Quince Road and West 6th Road drive like maniacs, and both Quince and West 6th Road are awfully close to the Tinkle property. The Tharp men and Sheila Tinkle are really nice. We will miss Sheila Tinkle. But we feel Sheila Tinkle could get a lot of money for her house and land, and the Tharp young men would benefit from a larger piece of land where their houses were far back from the road, with no running water on the property, where future children could run safely and free.
Okay, thank you. Anybody else want to speak against? Okay, no correspondence?
No, sir.
Motion to close?
Yes, sir.
Second? Those in favor say aye.
Aye.
Opposed, nay. Motion carried. Public hearing is now closed. Else got any questions? I guess after the meeting, me and Ty will have to sit down and go through this minimum lot size, so.
The request.
That was second?
I second that.
Motion made second to approve. Lori?
Mr. Bennett?
Yes.
Mr. Hostetler?
Yes.
Mr. Kephart?
Yes.
Ms. Mears?
Yes.
Mr. Gustafson?
I'm going to vote no on it, but that's okay. You guys got it passed, so.
You're okay.
You guys are good to go.
You're good.
Go with Ty, and he'll tell you what else you have to do to do everything, so.
Okay.
Okay. Second case,
You want the
24.
chair moved back or leave it here?
You can put it back, that would be fine, thank you. Second case, 24 BZA 35 was withdrawn, so we'll go to the third case, 24 BZA 36, Peter and Vicky Piquet.
Good evening. I'm Steve Snyder. I'm an attorney representing the petitioners, 200 West Main Street, Syracuse, Indiana.
Okay, and you, sir?
I'm Pete McKay. I'm the owner of property at 3295 Lakeshore Drive, Bremen, Indiana.
Okay, you guys are welcome to have a seat.
If I may, Mr. Chairman, I have some materials to offer.
Sure. Just, you would start down there and give it to him and work your way this way.
I'll get a copy for everybody.
Thank you. Thank you.
That's where all these lots look the same. You know. I like this, yes.
Thank you. Okay, Ty, you want to go ahead with your presentation?
Thank you.
Ty's going to go ahead and do his presentation, and then you can talk after that, if that's okay.
Thank you.
All right, so the applicant is seeking to permit the existing hedge at 3295 Lakeshore Drive, Bremen, Indiana. Based here on the exhibit for the lot plan, the shrubs are located within the two blue circles on the east and south hand sides. There's the lake access easement on the south side, which is an extension of Addison Street. And then the shrubs are along Lakeshore Drive. So here are some of the pictures that were previously shared along Lakeshore Drive.
Laura, can you shut that?
Thank you.
Never mind.
It's just pictures of these.
So, moving from the pictures to the aerial photography, via Google Earth Images in July 2022, you can see the difference between the shrubs that go along the road and the lake access have grown
Substantially.
in width in comparison to March 2005. And then we went out and took additional pictures this week to show kind of where we're at today. So as a point of clarification, on the top you have today's standard in relationship to fences, hedges, and walls for restricted fencing located within town residential and lake residential districts. No fence, hedge, or wall may exceed 3.5 foot in height within the given distances, which include for lake districts the front and rear or the lake and roadside of the property. But this is in contrast to the original definition and restrictions that had adjusted in 2007 when the ordinance was rewrote in its entirety, where the point of interest for this one is the third to last line in the middle where it reads, L1 Lake Residential District, no fence or wall shall exceed 3.5 foot in height, nor shall it have less than 75% of its surface open to permit visibility. What you see different there is the lack of hedge being included within that section. So whether it was implied or implicitly, or whether it was implied implicitly, the fact that it was not explicitly put into there makes it a much more gray situation with that definition and application. And then when we talk about grandfathering in general terms under Article 8, the first two sections read out, upon adoption of this ordinance and official zoning map, some structures, lots, and uses may no longer conform to the regulations of the zoning district in which they are located. For this reason, this article has been generated to provide the rules, policies, and regulations that apply to these structures, lots, and uses, referring to as legal nonconforming. Now, under 8020, a structure or lot which was constructed or is being used without an approved improvement location permit or approval from the Board of Zoning Appeals or Planning Commission is considered illegal nonconforming. An illegal nonconforming property shall be subject to actions and penalties allowed by this ordinance and all other applicable county laws, and shall be altered to conform with all applicable standards and regulations of this ordinance. Further, Further, an illegal non-conforming structure, lot, or use is created at the fault of the owner, tenant, or property manager. Legal non-conforming differs from illegal non-conforming in that the reason for the nonconformance is caused by the enactment of a zoning ordinance or a change to the zoning ordinance, including the official zoning map. The structure, lot, or use is not changed, but due to the zoning ordinance enactment or change, the property no longer conforms to the policies and standards of the zoning district in which it is located. When this situation occurs, the property is deemed legal nonconforming or grandfathered. This all kind of comes about because the shrubs or trees, and that classification we'll discuss later, is all planted prior to the 2007 ordinance where hedges were not included within that restriction section. To kind of move on to the procedure aspect, the Board of Zoning Appeals reviews and makes a final decision on this case based upon the findings of fact as defined in state statute. For the analysis, the applicant is seeking to permit the existing hedgerow that exceeds the fencing standards. Per the applicant, the previous owner planted the hedges in 1980 and have been maintained by the property owner in NIPSCO. The request is before you due to a collection of violations being turned in by neighbors on each other. For findings, the public health, safety, and welfare, use and value, and strict application are taken into consideration. For finding number 1, the approval should not be injurious to the public health, safety, and general welfare. For finding number 2, the use and value of adjacent property should not be substantially affected. For finding number 3, the strict application would not permit hedges of the style on lake residential property. So for recommendation, based on the information provided and reviewed by the Technical Review Committee, staff and TRC would recommend approval of permitting the hedges. For additional information, the proposal in front of the BZA is solely in relationship to the existing hedge on the east and south sides of the property. The current ordinance is in reference to hedges and walls reads as it is. Reference to fences, hedges, and walls reads as part as 1, no fence, hedge, or wall may exceed 3.5 feet in height, and 2, a fence, hedge, or wall or shade shall have a visibility of 75% of its surface area open to permit visibility. This is different than the original 1974 ordinance that indicated in part no fence or wall shall exceed 3.5 feet in height, nor shall it have less than 75% of its surface open to permit visibility. The fencing section remained unchanged until the zoning ordinance rewrite in 2007. Now, based upon some of that conversation, we reached out to Purdue Extension, and they have a certified arborist on staff. Similar to our ag agent here in Marshall County. Theirs is certified as an arborist, and one of the things brought up is the differences between between shrubs and trees. And it gets to be a gray area, but the species that's planted is more towards the tree aspect. And we don't necessarily have definitions in relationships to hedges. So if it leans more towards tree, it leans more towards tree row, so there becomes an even more gray conversation about the applicability section to that. Now, the intent behind it begins a whole different conversation. But when you start looking at what is a tree, what is a shrub, having had a conversation with a certified arborist, it begins to lean more towards tree based on their interpretation of what it is. So, with all of that information to share with you, it is now for board determination.
So a tree is allowed if it's a tree?
We don't necessarily regulate trees in the Lake District.
And these are only for property lines or blocking vision, or what's the?
So, if Mr. Piquet wanted to rip out all his shrubs and he wanted to put up a fence in line with the side yards of his property and go from side yard to his house and pick up on the opposite side of the house and continue his privacy fence all the way to the other property line from north to south, he has every right to be able to do that within the ordinance itself. So from a visibility perspective, from front of property to rear of property, road to lake, he can have virtually no visibility from one side to the other. The visibility standard is through the fence itself, within the front and the rear yards. So if you were to put a fence up, it could only max out at 3.5 foot and 75% see-through, which is often a chain link fence or aluminum rod. Right, so we're talking is the relationship between the front of the house towards the road, how high could that hedge be or how see-through could that hedge be? But a lot of the conversation with the arborist was this is more of a tree, which adds a lot more complexity to that whole aspect that was not anticipated whatsoever.
And that picture that you showed in the beginning of the 2005, can you pull that back up?
Sure. Just a few pictures back. Good. There you go.
'Cause that's the first I've seen that picture. Okay. Anything you guys would like to add?
I would. The materials that I handed out to you, I just want to go through those and indicate to you that, in my opinion, we're here without a reason for a decision, because we have a non-conforming use based upon your ordinance. Indiana law has been very clear in zoning matters that zoning ordinances are in derogation of common law. Common law said you can use your property for whatever you want to use your property for. That became an unreasonable situation. In 1947, the state legislature authorized zoning by municipalities. It had been in effect in larger cities long before that. But it's to be strictly construed in favor of the free use of property. Indiana law has stated that from the day the Enabling Act was adopted by the legislature in 1947. In this particular case, we have a statement from Denny Miller, whose parents actually planted the hedge, along with some photographs going back a significant number of years. The hedge was planted in 1984 and 1985, so the zoning ordinance in effect at that time controlled what could be done with the Miller's property as it was then. Your zoning ordinance said that fences, walls, and hedges are permitted in side yards and front yards. And then it went on to regulate only walls and fences and didn't say a thing about hedges. That ordinance was amended several times after that 1974 date, and it wasn't until the 2007 rewrite that it actually made mention of hedges within the regulation. As a result, whatever existed in 2007 in the form of a hedge would have been a non-conforming use, because non-conforming lots are in fact non-conforming, just like non-conforming structures can be. And you can't enlarge them, you can't go out and plant more trees in that area, but you can't order the removal of what was done legally in 1984, which was the planting of the hedge. So I've tried to include references from the prior ordinances in addition to the statement and photographs from Denny Miller. And once you get through those photographs and you can see what was planted, then we come to the 1974 ordinance that simply said fences, walls, and hedges may be permitted in required yards or along the edge of required yards, provided the following requirements are complied with. And it states, quote, "In the required rear yard of an L1 Lake Residential District, no fence or wall shall exceed 3.5 feet in height, nor shall it have less than 75% of its surface open to permit visibility." Well, that makes sense. Hedge is not included, because if you have a hedge, it's going to be impossible to keep it 75% open. It's going to grow together. That's what hedges do. Now, based on what Ty indicated from Purdue, we agree. We have a letter from an arborist saying this is not a hedge. These are trees. And you could plant trees, even under today's ordinance, in the area that we're dealing with, because they're not a hedge, a fence, or a wall. And Your ordinance even permitted hedges in 1974. The ordinance was amended in 1989, contains the same reference and says no fence or wall shall exceed 3.5 feet in height and shall remain 75% open. The ordinance was amended one more time in 2017, and it says restricted fences, side yard fences are limited to 6 feet in height, didn't speak to any other provisions of the ordinance. And then in 2019, an amendment regarding fences, hedges, and walls are subject to the following restrictions in the front yard of T1 and in the front and lakeside yard in L1. Prior to this enactment in 2019, there was no restriction on L1 lake residential except in the lake yard. The 2019 amendment expanded that to also exist in the lakeside setback and the front setback. So both the roadside and the water side of a lot had that restriction. You've seen, and Ty showed you, the current version, which says fences, walls, and hedges. So let's deal with that at this point. Even if you consider it a hedge, it's a legal non-conforming use under your section 8-20 of your ordinance, and it can stay the way it is, even though it would not be permitted if you tried to plant those trees today. Simply would not be permitted. And your ordinance says any lawful use of structures, land, or structures and land in combination established prior to the effective date of this ordinance or its subsequent amendments that is no longer a permitted use in the district where it is located shall be deemed a legal nonconforming use. A legal nonconforming use may continue provided that it remains otherwise lawful. That's the first provision we're dealing with in regard to a hedge. Now, the second is, and there's a letter, Exhibit H, that I've provided you from NWI Arbor Care, which indicates that this is not a hedge. Arborvitae are trees, and as a result, they can be planted in the street yard or the lake yard. Your ordinance does not prevent that. Just to give you an indication of what these are like, I included a photograph, Exhibit I, of the trunks of those trees. When you start nitpicking between a hedge and a tree, as Ty indicated, the area becomes gray, and grayer than most areas. But in my opinion, reading your ordinance and looking at the evidence, it's very clear this is a non-conforming use. On my own property, I have a few Japanese maples. They're relatively low, but they'll grow 7-8 feet tall. And depending on how you trim them, there's no question it's a tree, a single trunk. Depending on how you trim them, they'll grow all the way to the ground. And if that's the way you want them to grow, you continue to manicure them in that way. And they could be 8 feet apart, and still you would have no view through them. So what we're dealing with here is a tree, but it's a tree that you can't see through. And under your ordinance, I don't even think your ordinance applies because they're not a hedge. They're trees that happen to have, in this case, pine needles that have grown together because of the branches. But we don't even think it's a hedge, it's a tree, as both Purdue says and our independent arborist says. Finally, courts have considered, one, is there a right to a view? And it always comes up around the lake. There's no question about that. And there was a townhouse built in Mishawaka no, sometime in the early 2000s. And it had a bridge in front of it that the city put in. The townhouse filed suit against the city saying the bridge blocked their view of the river. The Indiana Court of Appeals considered that in 2008. My Exhibit J is a quote from that says, riparian owners, or non-riparian owners, if you will, don't have any right to a view. It's the same old situation that if you want to maintain a view of the lake, you should buy some lakefront property, because there is no right to a view over your neighbor's property, as Ty indicated. If Mr. Piquet wanted to put a fence up, even with the front of his house that was 6 feet tall and solid, he could do that under your ordinance. There's nothing to prevent it, and there still wouldn't be a view. But that's argumentative. What we're saying here is purely procedural and legal, and that is we have a non-conforming use if it's in fact a hedge. If it's not a hedge, we don't have any violation of your ordinance at all, because trees are permitted to be planted in this area. I think what you're looking at tonight is making a finding that this is not a hedge and the ordinance doesn't apply, or in the alternative, finding that it was planted in 1984, it was a permitted legal use at that time, and remains a non-conforming use.
Any questions?
I just have a statement. I think it's neither here nor there. Hedge, you're using it as synonymous, and if I need to talk to an arborist at Purdue, I will. Hedge isn't synonymous with shrub or bush. Hedge describes how you plant it. You can take trees and plant them in a row, and that is a hedge. You can take bushes or shrubs and plant them in a row, and that is a hedge. So I want to get that straight. To me, this is a hedge. It's a hedgerow of trees. But, does that apply, is it grandfathered in? I don't know, but I don't, in my opinion, it is a hedge. And I believe if I contacted Webster's here, and I think the definition of hedge Webster agrees with me. Trees or shrubs.
Okay. Questions? Do I have a motion to open public hearing?
So moved.
Do I have a second?
I'll second.
Motion made and seconded to open public hearing. Those in favor say aye.
Aye.
Opposed, nay. Motion carried. Public hearing is now open. Anybody here to speak in favor of their request? Come on up. You'd state your name and address for the record, please.
My name is Joseph Skelton. I live at 3329 Lakeshore Drive. I've lived over there since 1980. We bought the property, and we lived there full-time all this time. I haven't had any problems with trees or hedges or whatever it's called, but to me, Mr. Piquet takes excellent care of that property, takes excellent care of those trees, and I don't see any problems with having them there. I think it makes it look better more so than trying to block anything. So,
Okay, thank you.
that's all I know.
Anybody else to speak in favor? Anybody here to speak against? Come on up. And if you would state your name and addresses for the record, please.
Terry Holderman, 8606 Addison Street.
And you, ma'am?
Penny Holderman, 8606 Addison Street.
Okay.
So basically, I have a nice file here full of ordinances that we can go on all night long here. I do not want to go through that. I know y'all don't want to go through that, okay? The point is, we have he's lived at this house, at our 8606, since he was born. Lifelong residence. He's 59 years old. I've lived there for 30 years. We have always had vision to the lake. Always. Let me rephrase that. for the last 15 to 20 years, we have not had vision. We have asked repeatedly for those bushes to be cut back down to the way they were when Millers planted them. They spoke to my father-in-law, God rest his soul, about planting them, promised that they would never overcome the vision of what we could see out our door, out our window, okay? That promise was made to us by the Millers. Millers sold the house. We have asked for years for them to be cut down. They are overgrown 15 feet into the public easement. They're overgrown all the way to the road. We have pictures that shows where the tops of them are now in V shapes, where NIPSCO just comes through and chops them up every couple of years because they're up in the power lines there. That's not taking care of them. That's not keeping them nice. Keeping them nice is keeping them trimmed up and on the property line. We have where the property line runs. If he put a fence up, as was spoke, we could put a fence up. We could still see the lake if he had a fence up because it would be on his property line. He is 15 feet off his property line into the view of the public right-of-way. We could still see if he had a fence there, trust me. As far as right-of-ways go, it said if I went right-of-way to the lake, I would buy property for lakefront. Well, from 1948, this Smith Shore subdivision that we live in, we were dedicated a 10-foot right-of-way across all the property in the front of that plot. It's in the records. I have those court records that show where it's been in the Marshall County Court before and with DNR. We legally have a 10-foot right-of-way, and no structures were ever supposed to be built 25 foot from the lake inward. And there are permanent structures that are now in that. So as again, I said, I could sit here and go ordinance, ordinance, ordinance all night long and show you all the violations. That's not what I'm here for. I'm simply here to ask for him to bring these bushes back to the normal size of a bush so that we can see from our property that we have owned for, I mean, my father-in-law owned it long before that. So he's lived there, like I said, almost 60 years. We just want to be able to see the little bit of lake that we can see. So, do you have anything else, Terry?
Yeah. You guys want to say the rights. Is it rights for him to put the bushes on the easement now?
Oh, yeah, now he's planted more trees or bushes or whatever he wants to call them. They are now planted on the right-of-way, on the
Hand to him
easement.
and he'll look them over
Okay,
and pass
this
them
is the
down.
trash wood that they cut out of his trees. That is on the easement. These two bushes are on the easement. They're not in his yard no more. So he's going to be allowed to keep moving everything over onto the easement farther and farther? Oh, where's that other picture?
I don't know.
Oh, wait a minute. Just pull your picture back up,
Please,
please.
which picture?
Which one are you looking for?
Take a deep breath and calm down.
Give me the property lines. Where's
Please.
the property in, please?
You need to tell him which picture, Terry.
The pictures that show the property. Okay, yeah. All these people, all this that's out here is not supposed to be there by legal standards.
I don't know where you're pointing to, sir.
We can't see it.
They can't see where you're pointing.
Everything from the,
Where the easement
Blue line.
is, where the old,
line
Yeah.
for the.
Yeah, from
that is
Abbott,
25 feet from the
Addison.
lake.
okay.
So some of those,
It's not even an issue.
these are overlaid, these lines are overlaid over areas, and they don't always line up. If you look at your house, you'll see your house actually, for this photograph, extends 5 feet over on your neighbor's property, so.
Right, right. No, but what he's referring to is that 10-foot,
The 25 feet setback.
the
that they ain't
25-foot
supposed to be in.
setback that's,
That's 25 feet. I got a picture somewhere here. His fire pit, 25 feet back, and he ain't supposed to be 8 feet or something like that, close to that. He's 5 feet over with that, plus a sidewalk going clear to the lake on property that belongs to everybody, not him.
and
Every other one of them, not their property, but yet they can put a pier, they put, or not a pier, patio deck out at the lake and then tell me I can't walk on my property? That is my problem with these guys. They keep pulling shit, saying that they're doing right. I want the permit where he got the seawall put in on the end of that easement there.
Terry.
He's got no permit.
So he's the only one that has a seawall there? There's everybody does.
The public easement.
County actually approved me.
He turned around, and put fieldstone in at the end of the easement.
That's the same house.
Where's the permit for that?
I mean, we have more pictures.
He
I do
doesn't
have
a
pictures
permit
of
for
the,
that. Where's the permit for him to put a patio deck on our property?
I do have pictures of where the rock and stuff and the steps that were put in on the easement. We have pictures of that as well. You know, there isn't, again, I'm going back to the previous meeting, I watched it online afterwards, and I heard the comments say, oh, you know, my wife saved the baby, or, you know, got this baby or whatever from a pier. The pier hasn't even been out there since.
That doesn't affect it has nothing to do with us.
Right, well, that's what I'm saying, the pier hasn't been out there for years.
See,
So, I mean, that's what I'm saying, we could go on and on and on about, and these are legitimate ordinances in the county ordinance book that has been pulled up, that is numerous violations, and all we're asking is for these bushes to be trimmed down. And again, if you want the privacy, put up a fence, because we can still see the lake if there's a fence there, the way the property line runs. Let me
He
see if I can
stated I
find
never
you.
could see the lake. But yet, if the bushes wasn't put in there, which Miller told me they'd never be over 3'8".
And
And then he tries to tell you that I've never been able to see the lake. But yet, if you took them bushes back out where they was down at 3'8", the whole side of his garage, from my living room or dining room, my living room window, I could see the whole lake. For years, I could see
No.
the whole lake.
No, you
Out
can't.
across the lake.
I was there today. I was at your house today. And
From
looked
my
through the-
living room window, I can see the side of his garage, which I can see the lake. Would have been able to see the lake.
Okay. Is there anything else you would,
And the one that bought the property, has the property next to him, cleared some of his bushes because he realized that, yes, he blocked my view of the lake.
which house is that, to the north or to the south?
It would be to the south.
So,
So
I gotta keep
what
looking,
about,
but like,
what about the bushes, the water bushes on the south side of the easement? You see them?
That's what I'm saying. He cut,
so like,
he turned around and
this
started cutting some of
picture-
his back.
which I could pass up as well. So this picture here,
Ended up.
where this telephone pole is, on that side of the telephone pole, is his property line. So that's how much, from that picture, you can see that's overgrown.
Because that water, you can stand it to him at the end and we'll all
In
look
charge
at
of the
it.
easement. Who would be in charge of that easement?
You have to ask Ty.
Ty, who's in charge of that easement? Keep those bushes off of it.
Well, we
To keep the bushes off of it.
Well, like I'm seeing, and I don't know if that's correct, but in the easement going to the lake, there's a big pile of trees or bushes right there. Is that in the easement?
Going clear to the lake.
Without pulling a survey
Okay.
and determining exactly where that property line is.
Okay.
The fence that's their property line.
Would it be the county or the DNR, wouldn't it?
Chain fence.
It'd be the
Maintenance.
different easements have different ownerships around the lake. And so without pulling that exact one, I couldn't tell you.
Oh, okay.
Some are owned by the county, some are owned by the Property Owners Association, some are owned by third parties, some are public, some are private, some are
Do you happen to
private
know who
within the
owns that
subdivision.
easement?
The county
Yeah, it is
does.
public.
Abbott,
That is a public
Abbott
easement.
and Addison both are public easements. Marshall County owns that. I have that in these court papers that.
Are they out there maintaining it, Marshall County?
Actually, no. For years, we maintained it. My father-in-law mowed it.
Joe Skelton? or
No, Joe.
Eganoff.
Eganoff mowed it. Terry's mowed it. In the last 10 years, he decided that it was his property, so he was gonna take care of it. according to what I have read through all of the court papers, when this came to a whole different situation, but it was all about the easement, it was deemed that that is a road to the lake. Like, even though it's grass, it was a road to the lake. And we're not even allowed to put our canoe or our kayak in the water down there without having somebody yell at us, or they call the police out because we're driving on that. It's not somebody's property, it's deemed public access right away to the lake.
Was there a pier there at one time?
Yes, sir. That's the
Okay.
pier I was talking about.
And I'm,
It was
I don't live on a lake, don't know much about lakes. Is that the pier that that was called the county's pier?
Yes.
And everybody was able to use
Everybody
it?
used it. We
And
used it
then
for years.
somebody made them get rid of it?
Yes,
Okay, so that's,
they made us get rid of it.
okay, so that's where,
They threw a stink and then, and then Marshall County said, wait a minute, we're not gonna be liable for any damages from a pier on our property, so you have to take that off the public property.
so you had your boat docked at the pier, or?
Yeah, at that time,
Our
yes,
neighbors did.
we had our,
Okay.
everybody on that street did. I mean, we had
Yeah.
pontoons out there, the kids would go out there, and
And then
then
you
just,
would walk down the easement?
Yes.
Now that that's all gone, okay,
now that's all gone,
okay.
yes.
I-
So,
I just wanted to make it, I know it's more than just the bushes of what's going on here, so I just trying to figure it out. So,
but,
Okay.
and you know, and I'm just showing you on the pictures that, again,
I
it's
was,
a much more overgrowth,
But it's
and
just this
this,
lane.
we take care of them is not there.
okay, I was out there today. I went to several of the things that we're gonna look at tonight, because I live by Swan Lake Golf Course, and I went to Walkeroosa to get feet. So I just so I've been through pretty much every thing we're gonna go through tonight. I've seen it today, okay? So I sit there, and I don't get out, because I didn't want to talk to him, I don't want to talk to you.
Right,
I want to, so I just set my pickup truck, and I see you have just one window on the west side of the house, right?
yes.
I've got
Okay.
a bedroom window and
No, we,
That you can see out. You have
one
the
window that
pole-
we
the
can
pole
see out
barn-
to the lake, yes.
The pole barn sits between your house.
Yeah.
I let you talk, right? Let me talk. Okay, so the pole barn sits there, so you just have one window. So if I park my truck right there, there's very little of the lake you're gonna be able to see. I took on GIS here, and I blew this up, and I put my measuring device at the window of your house, and I drew a line going out to the water. And from the corner of his house, there was very little that you could see between his house and the next house to the north, okay? And if I took that line, and we could do it here, it's the same thing on there going south to the guy that has the bushes there. Now, are you asking that guy to get rid of his bushes too?
He was at the meeting last time. He didn't know what they was pulling. He turned around and trimmed his bushes up.
But it's not about
I
getting,
didn't, there's still bushes there. I seen them today.
it's not about getting rid of the
Talking
bushes.
about taking
It's
it.
about when the
Trimming 'em up.
bushes were 3.5 foot tall, we could see over the
So,
bushes.
when he owned the property, were they ever 3.5 feet tall?
When he bought the property, yes.
They wasn't quite 3.5. They was a little bit higher than that.
Considerably.
But he says they was way higher than that. They put them in on the other side of the lake.
No,
Got another one of my friends that I work with pissed off because he can't see the lake anymore.
Okay. And I drove down south of there, went all the way to, I don't even know what the road is, and I drove along there. And there's other ones. I guess I was more looking at the ones going along the property line. I didn't realize the ones along the fence were the issue. So, but anyway, anybody else got any other questions?
Nope.
Okay. Okay. If you want to go back to your seats then, and we'll ask for anybody else that's against. Have you shown us everything you want to show us?
Have you,
Well, I'm just want to know why he can put bushes on the easement now. Because them pictures are on the easement.
Okay.
The trash is on the easement.
Anybody else here to speak against? Any correspondence?
We do have some correspondences. I believe some of them might have been in from last time, but I'll go ahead and read them.
Go ahead.
And again for record. First one is, to whom it may concern, I am Tom Evans. My wife and myself have owned the home at 3281 Lakeshore Drive, Bremen, Indiana for 8 years. We are 2 houses down from the Bouquets. I am very familiar with the hedge on the roadside of their property. The shrub is well maintained and does not create a blind spot for traffic. In my opinion, this actually adds to the curb appeal. Rather than looking at all the driveways along the stretch of the road, there is a break in the scenery. I have absolutely no problem with this hedge that has probably existed for over 30 years. Apparently, the zoning board also does not have an issue, otherwise something would have said before the shrub grew to 30 foot. Perhaps this code did not exist 30 years ago. If that is the case, the issue should be grandfathered. I'm very much in favor of granting this variance. Tom Evans. And then, what was his letter? And then the next one is, I'm writing in support of the above request for variance of front yard hedge height of the Bouquets. My wife and I live next door to the Bouquets. We appreciate the hedge as it is and is well maintained. It has never been an issue as far as we are concerned. Fred and Laura Anderson, 3291 Lakeshore Drive, Bremen, Indiana. And then I have another letter from Tom Evans.
That was 3291.
And 3290.
3281 and
91.
3291.
What about 3329?
I only have the 3 letters, and it looks like Tom Evans' letters here twice.
Okay.
And that's all I have.
That's all I have. Do I have a motion to close?
So moved.
Do I have a second?
Mr. Chairman, do I have an opportunity to respond to?
Yeah, we'll close the open public hearing.
Okay.
And then you guys will be able to respond. You'll be able to respond to what they talked about. Do I have a second to close the public hearing?
I'll second it.
Motion made and seconded to close the public hearing. Those in favor say aye.
Aye.
Opposed, nay. Motion carried. The public hearing is now closed. Now you can talk.
Thank you. First of all, I want to say we're not here to resolve title disputes, if there are any title disputes regarding easements, public ways, lakefront ownership, or anything else. We're here solely on the question of these trees and whether they qualify as a non-conforming use under the ordinance that was in effect in 1984 and 1985 when they were planted. The second question is whether they are a tree or a hedge, and obviously we have differing opinions, but the arborists who have looked at these have said these are trees, they are not a hedge, and the fact that they may block someone's view is really of no consequence in light of the terms of your ordinance that has been in effect until the most recent amendment, which actually added hedge to fence and wall in the restrictions of size and height. So I don't want to muddy the waters with who has a right to put a pier out on the lakefront or anything else. We're merely here with a zoning issue that comes down to 2 things. 1, is it a hedge or are they trees? And 2, is it a non-conforming use? And one of those 2 is going to answer the question. If you decide it's a hedge, then it's still a non-conforming use under the ordinance that's been in effect until your most recent recodification. And it can stay as a legal non-conforming use because in 1974, which was the ordinance that was in effect, it said fences, walls, and hedges may be placed in side yard setbacks and front yard setbacks. That's what it said. Then it restricted only walls and fences, not hedges. And I urge you to just disregard the issues whether we could or couldn't have a pier or whether the county maintains the easement, et cetera. Those aren't of any effect in today's decision.
The only reason I brought that up is there's more to it, and I just was trying to figure out what it was, so.
We present this to.
Yeah, they don't need that.
A lot of information to take in, and I'm not a lawyer, so can you interpret it to us, for us?
What would you like interpreted?
Is it non-conforming? Was it there? Is everything he's telling us, do you agree with?
Yes, the ordinance did not explicitly dictate the term hedge. Now, whether it was implicit when they had conversations with the department or anything along those lines, there's only a few people that could actually affirm that.
It was planted in.
It was planted before the ordinance explicitly dictated whether or not a hedge can be in that location.
Okay, so that's what I want to know. So when it was planted, it was legal to be planted then?
Right.
And it's
Okay.
grandfathered since.
And it's grandfathered since then?
It'd be a legal non-conforming. How you classify it as a use or a structure, that's a whole legal interpretation of itself. But the fact remains that if you consider it a hedge, and a hedge didn't get regulated, if you want to think about it that way, in terms of the ordinance itself, until post 2007, which is after the date of planting, that use or that hedge will have been in effect prior to that. It would be in essence grandfathered.
Okay. Does everybody understand that?
I hope I answered your question.
So yes, it's okay to be there. It's legal to, or it's a non-conforming, it's legal.
It's a legal
to be there because it
non-conforming
was
use.
there before.
In about one of the most complicated ways, yes.
Okay.
Well, then is he seeking a permit or is, what's his remedy? What's our remedy here?
So he is asking, go ahead.
The interpretation came back several months ago in relationship to what the ordinance sits as today. And the information leading up, including information with Purdue Extension through today itself, was that conversation of, is it a tree, is it a shrub? Really builds to the whole conversation about how do we want to begin adjusting or not regulations as it relates to trees, shrubs, hedges, establishing definitions, those sorts of things in relationship to it. But regardless, this planting, even though it has grown to some degree over the years, and that's showcased in the comparison of aerial photography, at least in its width, it's difficult at best to determine its height, unless you really want to start getting into calculus. It's grown, but the nonconformity of its existence has been there since the 80s.
Okay, so we really don't have any choice.
You have a choice, but you're
The
defensible.
confusing part to me is if he's here he's asking for a variance to an ordinance that doesn't apply to him. Because it's
That's
a
the
legal
question.
non-conforming and grandfathered in.
Yeah, so there's nothing for us to do. as far as
All this
I'm-
discovery has come here.
Okay, so what you're
Right,
saying is,
the discovery all came post the decision to go through the variance aspect. You can do in short, you could propose two different options. You can approve it understanding that it's falling under the grandfathering aspect based on the reasons in the discussions discussed this evening, or you could deny it for what I'm unsure at this point.
can we do nothing?
No, he in theory could withdraw his request.
Is the county
For
fining
approval.
him, or why did he do the request?
It came through as a violation, and so the proposal was to get the hedge essentially approved as it relates to today's ordinance, but under the understanding today in comparison to the history of ordinances since '74, as well as the terms and definitions of trees versus hedges, the ordinance doesn't necessarily apply to that particular hedge in space. We've had a recent one that
Who filed the complaint for the ordinance, violation of ordinance, whatever we're talking about?
it's very frequent the neighbors
Who came
File
out?
violations.
Who came out and said it was a violation?
that it was our office.
Your office did.
Correct.
So you guys went out there and said he's in violation.
Correct, based on today's
Based on
ordinance, yes.
current
Based on it, okay.
So what you've heard his lawyers say today, do you still think he's in violation?
No, sir.
So he can withdraw, you'll leave him alone, and it's all done.
Could, yes. Or you could also approve it as well, as it sits today.
What I would suggest is what I suggested when I sat down, is that you make a motion that the variance is not required because the trees at issue are a non-conforming use. That way you don't have to go through your findings, you don't have to do anything else, but we have a record that we presented this and you made that determination so that a year from now, we don't have to go through it again.
And then if somebody disagrees with that motion, I mean, if that,
If you were to make that motion, I would lean towards a recommendation of approval based on those facts, without consulting with our own attorney on options, standard options or approval, denial table, or approval with condition.
I'd like to make one comment, because I think I might have talked about if you go around the lake, not just our lake, but Banks.
Don't go there.
Yeah, but
That's not an issue.
So, Ty, just to make things clear, based on the information provided and reviewed by the Technical Review Committee, you guys said you'd recommend the approval of permitting the hedges.
Correct.
So when you went out there to look if it was a violation, you didn't think so?
So we believed it to be a violation, but we did not see the issue with it. And since that time, we've come into the additional information of the historical ordinances and how hedges did not have the same regulations as fences and walls
Okay.
since '74.
Okay, thank you.
Well, if Purdue and all you guys that are way smarter than us can't figure it out, how are we gonna figure it out?
And so since it didn't apply, so going back to the recommendation from TRC, we would recommend approval on this because of those facts.
Okay, you heard what he said. Anybody in agreement to that, or?
I defer
I'm
to you,
feeling a
Trent.
split vote here.
I'm trying to get, your motion, the motion would be to, not, well, we're really not approving a variance, we're approving,
It's a variance is what has been requested. It's not, what was,
doesn't apply.
what was not requested was an appeal. He did not appeal the decision of staff on whether or not it is or is not applicable. He requested a variance of development standard to permit the hedge as existing in the face of the existing ordinance.
Well, because that's normally how everybody approaches. People can actually approach us and present for an appeal on your interpretation?
Correct.
Or your office's interpretation?
Yes, an administrative appeal is what it's called.
Never had one of those in all the years we've been here.
Yeah, we may have had one.
You have told us before that Pretty Lake is the only one that has a line of sight.
In county jurisdiction, yes.
And how
Culver's the
how
other
can
one.
Pretty Lake be the only one of the lakes in the county that has that?
Because they specifically got it written into the ordinance for setbacks.
Are you kidding? Oh.
No.
So if this was Pretty Lake, they'd be gone.
Still be pre-existing, wouldn't it?
I think the sight lines only apply to homes on lake frontage. You can't apply to a house and back.
The
Normally
the sight line is when you build adjacent to the residences next door.
Nothing to do with fences then, or hedges, or trees? Or, I won't
Well,
say
true,
trees.
but you're still.
Fences are still restricted to 3.5 foot tall, 75% opaque.
Okay.
And you still have to meet the setback requirements, so depending on where your house is laterally between the road and the lake itself, makes a difference.
They're headed in the right direction.
So instead of withdrawing, you want us to make a decision, is what you want?
Well, as I indicated, I don't want to have to come back a year from now because there's another complaint filed. I would like some determination from the board that you agree that it's a non-conforming use. And the way I see that happening is you move to approve the variance requested for the reason that it's a non-conforming use and no variance is technically required. That solves the problem.
Can you explain non-conforming? Just,
Yeah, it's the definition that's contained in your ordinance.
can you explain it?
Yeah,
What
it's-
non-conforming means?
Yeah, non-conforming use is some use, let's take a building because it's easier to work with. It's a building that has a 5-foot setback where your ordinance now requires a 10-foot setback from a sideline. And it existed prior to that imposition of a 10-foot setback requirement. Because it was legal at the time it was built, it is a non-conforming use, but it's a legal non-conforming use. If it had been built in violation of some setback when it was constructed and still remains even more in violation, it would be an illegal non-conforming use. It's not grandfathered.
But a conforming means that it fits all of the rules.
Yes, a conforming use
Have a
would be,
conforming is everything's, we wouldn't even be here.
That's right.
Non-conforming is, it's not, but it's been
Right.
grandfathered in. Okay.
So if I make a motion that we grant your property or your hedges or whatever we want to call it as a legal non-conforming use of the property, that would solve this problem?
in my opinion, it would.
I'm asking him, I'm sorry, I was looking at you.
Correct.
That's what my motion is then.
Do I have a second?
Second.
Motion made and seconded. Lori?
Mr. Bennett?
Yes.
Mr. Hostetler?
Yes.
Mr. Caphart?
Yes.
Ms. Mears?
No.
Mr. Gustafson?
Doesn't matter, but I'll vote yes on it. Okay. Thank you.
Thank you.
You gotta go? Yep. Okay. Dave's gonna leave, so.
Don't pee the bed.
Okay, fourth case, 24 BZA 37, Jesus and Rosa.
Can I get the pictures back?
Sure, come up.
You want these?
Yeah. There'll be another court case going up. I'm not here.
Okay. Here's some more pictures, sir.
No,
Trent did.
Trent did.
Okay, if you would all state your name and addresses for the record.
My name is Jesus Galardo. I live in 1006 West Washington, right here in Plymouth.
I can't hear.
My name is Jesus Galardo.
Okay,
I live in 1006 West Washington, right here in Plymouth.
okay. Did you get that, Lori? Okay. You, sir?
Javi Gallardo, 12451 11th Road, Plymouth.
Okay, and you, ma'am?
Rosa Gallardo. I live in 1006 West Washington Street in Plymouth.
Thank you. Go ahead, Ty.
All right, so we have a request for a variance of use to allow landscaping business equipment to be stored at their family's property located at 20985 12th Road, Plymouth, Indiana, West Township, zoned AE1. And here's the subject property, a couple aerial flights, and the subject property as we pan across. The procedure for this is the Board of Zoning Appeals reviews and makes the final decision on this case based upon the findings of fact as defined in state statute. For the analysis, the applicant is seeking to receive approval of their landscaping company to store materials and equipment on the property with hours being Monday to Friday, 7 a.m. to 6 p.m. They currently rent the property but have determined that this is the best location for them to store equipment and materials. Typically, similar uses are home-based businesses, which are ran as a special use, but since the owner does not live on the premise, they need to follow a variance of use. For findings, the public health, safety, and welfare, adjacent property, strict application, unnecessary hardship, and comprehensive plan are taken into consideration. For finding number 1, the proposal should not be injurious to the public health, safety, and general welfare. For finding number 2, the use and value of adjacent property will be impacted proportionally to the scale of the operation. For finding number 3, the strict application of the ordinance would not permit the proposal. For finding number 4, the strict application of the ordinance does not constitute an unnecessary hardship. For finding number 5, the comprehensive plan supports small businesses in the agricultural district provided that they fit in their associated context. And for the recommendation, based on the information provided, staff and TRC would recommend approval with the conditions setting the number of employees, how materials are disposed, and the extent of business. It is now up for board determination.
Anything you'd like to add? Tell us what you're doing, or?
Pretty much what it is our family business is, we're just looking for a place to store our trailers and some of like leftover material from job sites that we have, because being a small business, when we have materials left over, we can use them for the next jobs that are coming up to kind of save the client some money and save ourselves some money.
What kind of materials?
We're talking, it'll be pavers, we do paving, decking, landscaping, timbers, cinder blocks for patios, and all we're doing there is just storing our trailers there and storing extra material that we have. Trash and all that will get taken to the trash. There is no like storefront for them to customers come in and out. All it is just strictly to store stuff, and it would just be between those. We would not be there on the weekends for any type of business there. Everything is done online and everything, and we go to the customers' houses for quotes and all that. So it's only meant to just store the items, nothing else.
About how many trailers?
We have 2 trailers. We have one trailer that's an 18-foot enclosed trailer for the lawn equipment, and then we have another trailer that's 16-foot for gravel and miscellaneous use. And it's 2 pickup trucks. But only one pickup truck will be there at all time, because the other trucks we use as vehicles to and from.
Do we have, I'm assuming they have verbal permission, or do we get written permission from the owner, or?
They own it, but rented the house out.
Yeah, we're the owners. We own it.
Oh,
We just
don't
have
live there.
Yeah, we have tenants there, which one of the tenants that live there is one of our employees.
Okay.
So that's why, we own the property.
So if they lived there, they wouldn't have to get this?
No, so the business has to be approved through the BZA regardless. The difference is a special use is a home-based business, which is standardly where a lot of the businesses come from, where they live on the property and they store their stuff on property. This has to run under a variance of use as essentially a commercial business within that space. And so that's the difference between the two, if that.
When we were doing violations, there was a lot of them right there in that row. Were you on then, or was that before you? Must have been before, if you don't remember. There were several of them right along that.
I know we had several in that region, but I haven't been out there too recently.
There was one set of guys that were not happy with the mess that the neighbors had, but I haven't heard anything about it for a long time, so I don't know if stuff. Go ahead.
I believe you're talking about like 5 houses down. There was a couple of old trailers and stuff, and there was a couple of people there that they completely trashed that area. It's about 5 or 6 houses east of us. That area was really, really bad years ago. It was like, the trailers had broken windows and
wasn't it?
Yeah, it was very, very bad. But that was years ago. All that, and I don't know if I think one of them passed away and they inherited it. Just kind of it went south after all that happened.
Okay, I've been on there a long time, so I just remember. So 2 trailers, a little bit of pavers.
That's it. Just 2, like I said, 2 trailers, pavers.
You're just gonna park them out back?
It's just pretty much just to park them there in the back corner. It's not gonna be right in front visible. It's in the back corner. There is a privacy fence already on there. So it's not like you can see anything.
Both sides of I see you're on the corner.
Yeah.
So do both sides of the property, back side yards have?
Everything is, yes, sir. The only thing you can see through is the tube gate that's in the front. That's the only visual you see. Everything else does have a wooden privacy fence along. And we did it more for that way the neighbors don't have to see our stuff there.
Okay. Any other questions?
I'll make a motion to open public hearing.
Do I have a second?
Second.
Motion made second and open public hearing. Those in favor say aye.
Aye.
Opposed, nay. Motion carried. Public hearing is now open. Anybody here to speak in favor of his request? Anybody here to speak against? Any correspondence?
No, sir.
Make a motion, we approve this request?
Well, you got to close the public hearing.
I make a motion to close public hearing?
Do I have a second?
I'll second.
Motion made and seconded to close the public hearing. Those in favor say aye.
Aye.
Opposed, nay. Motion carried. Now, if you would like to
Do
make
you have
one.
questions? I could probably,
Anybody have questions? Trent?
I
Okay.
make a motion, we approve the request?
Do I have a second?
I'll second it.
Motion made and seconded to approve. Laurie?
Mr. Bennett?
Yes.
Mr. Kephart?
Yes.
Ms. Mears?
Yes.
Mr. Gustafson?
Yes. Okay, you guys are all set.
Thank you.
Okay, fifth case.
Thank you.
Yep.
Have a good night.
Fifth case, 24 BZA 38, Vonda Burkholder. Come on up, that seat. You can grab one of them other chairs. You're welcome to grab a chair. And if each one of you would state your name and address for the record, please.
Dwight Burkholder, 781 Plymouth Goshen Trail, Napanee, Indiana.
You, sir?
781 Plymouth Goshen Trail,
your
Napanee,
name?
Indiana. Kevin Burkholder.
Okay, and your name, ma'am?
Vonda Burkholder, 781 Plymouth Ocean Trail, Napanee.
Okay, thank you. Ty, go ahead.
All right, we have a request for a variance of development standard to allow a confined feeding operation pull-up barn that does not meet the 1320 residential setback for 5 residences located at Beach Road, Napanee, Indiana, identified as parcel number 5054210016000005 in German Township, zoned A1. The building's 200 foot south of the north property line and 210 foot from the center line of the road. Here is a reference for the barn. This case is going to sound familiar to you because this was before you in 2023, but their time has since lapsed within that year time frame, and so they're back before you. The proposal has been adjusted from 2023 to 2024, moving it further away. As you can see here from the 2023 proposal, the nearest house due north is 504 foot, whereas now it's 560 foot. The barns are a little bit different in size. So the minutes from the 2023 BZA meeting was it was tabled in March and then approved 3-1 in April.
Do you remember what happened? They came in, had
They came in,
had all the
adjusted
neighbors
it.
signed a paper, and then the neighbors were here and said, no, we don't want it. And then they had to come back in and redo it, so.
Right, and they slid it south at that point.
Pardon me?
They slid it south at that point.
Was I here for that?
So here are some pictures from the property. So the procedure for this is the Board of Zoning Appeals reviews and makes a final decision on this case based upon the findings of fact as defined in state statute. For the analysis, the applicant is seeking to construct a CFO, confined feeding operation, double layer barn for poultry within the prescribed 1,320.
Can I correct you there? That's supposed to be a pull-up barn. That was, because
Instead of
it
poultry?
came from a layer, barn to a pull-up barn.
Oh, okay, apologies. Within the prescribed 1,320 foot from the nearest adjacent residence. The proposed structure is too close to 5 residences, which have separations of 560, 620, 746, 944, and 1129 feet. The double pull-up barn is proposed to be 52 by 540s. With pasture on the north and south sides of the building. The manure storage will be located in between the 2 buildings. The 5 residential neighbors, Keith and Mary Burkholder, 668 Beach Road, David and Doris Hostetler, 703 Beach Road, Willis and Frida Burkholder, 634 Beach Road, Jerry and Alma Helmuth, 570 Beach Road, and Jonathan Sharon Helmuth, 536 Beach Road, have signed in support of the project. For the update, for the additional information provided by Agronomic Solutions, the operation will not be identified as a CAFO. CAFO is a concentrated animal feeding operation. A CAFO is identified where there are greater than 125,000 pullets with the solid manure handling system. The proposed project will have 2 layers of 50,000 each for 100,000 total hens. The applicant will be required to receive IDEM approval prior to the building permit. The project was previously approved in 2023, but it did not act on its approval within the allotted timeframe and had to return for the BZA for approval again. So for the findings, the public health, safety, and welfare, use and value, strict application are all taken into consideration. For finding number one, the application should not be injurious to the public health, safety, and general welfare, but may be proportionally injurious the greater the setback reduction. For finding number two, the use and value of adjacent property may be impacted proportionally to the amount of reduction. And for finding number three, the strict application of the ordinance would not permit the proposal. And so for recommendation based on the information provided and reviewed by staff, the staff would recommend approval of the project, and TRC also gave its recommendation of approval and is up for board determination.
Anything you'd like to add?
The only thing is, this did change from a layer barn to a pull-up barn.
So a pullet is a younger, non-laying.
Yes, so.
So what do you just take babies and take them to pullets and then they
Yes,
get
they will
moved to a
be
layer?
from chicks, day-old chicks to 16 weeks old. Barns will be cleaned out in between each.
So every 16 weeks they get?
Yes.
And you're storing the manure between the buildings?
Yes.
Is it enclosed or is it wide
It
open?
does have a roof on it. It is dry manure.
I do have a question.
Go ahead.
We're here strictly for setbacks, correct? We're not here to look at number of employees,
Correct.
things of that.
Purely
nature,
between
like hours
reduction of
business.
setback.
Okay.
And all of those people that wrote letters of support are the people that are within that shorter distance.
I have letters to share.
Oh, some up, okay.
I'll make a motion to open public hearing.
Second?
Motion made second and open public hearing. Those in favor say aye.
Aye.
Opposed, nay. Motion carried. Public hearing is now open. Anybody here to speak in favor of their request? Anybody here to speak against? Any correspondence?
Yes, I have three provided correspondence prepared by Agronomic Solutions. It's their standard form letter for neighbors. I'll read the first one, and then I'll give you the name and addresses for the following ones. To whom it may concern, I own land and a house north of Burkholder Family Farms, LLC in German Township, Section 21. I'm aware of the proposed livestock production facility, a pullet barn, being built by Burkholder Family Farms, LLC, to the south of my house and property. I fully support the project and hope that they will be granted the necessary residential setback variance needed to continue with this project. I'm signing this letter to agree to building being less than 1320-foot distance from my residence. Jonathan Sharon Helmuth, 536 Beach Road. The next letter, same letter, and this is signed by Keith and Mary Burkholder of 668 Beach Road. Same letter signed by David and Doris Hostetler, 703 Beach Road. Same letter, Willis and Frida Burkholder, 634 Beach Road. And fifth letter being Jerry and Alma Helmuth, 570 Beach Road. That's all I have.
So all five of them that are within the 1320.
Can you turn the address?
Send a letter.
No, because there's only got three.
We read five names.
I would say three.
Transportation.
There are five.
So if we.
Five homes.
So we have 536, which is the northernmost home of the five. Number two is 668, which is the first home north on the east-hand side. 703 is the northwestern west of Beach. It's the first home
Across the street.
across the street to the west. 634 is the second house north on the east side. And 570 is the smaller parcel, which is the third of the four houses on the east-hand side. So all five address points, 536, 570, 634, 668, and 703 are all five
Okay. That's what I was asking.
accounted for in
There you
residence.
go. I just said, well, only three. I thought there was five.
I thought I heard say three too, but.
Okay,
oh
well, I was watching the numbers, so. Do I have a motion to close public hearing?
I'll motion it.
Do I have a second?
Second.
Motion made second to close public hearing. Those in favor say aye.
Aye.
Opposed, nay. Motion carried. Public hearing is now closed. Was there any restrictions put on it the last time, or, I mean,
We will jump back to that motion for you, because I do not have that
It's
answer offhand.
expired, that was it, right?
Right, it's because it expired. So the approval from the 2023 BZA minutes, a motion was made to approve the request, and it was seconded. Voice vote 3-1, 1 against. So there was no conditions included.
Okay.
I'll make a motion to approve.
Do I have a second?
I'll second.
Motion made and seconded to approve. Lori?
Mr. Bennett?
Yes.
Mr. Kephart?
Yes.
Ms. Mears?
Yes.
Mr. Gustafson?
Yes. Okay. You got 1 year.
We'll try and get it done.
It will be written on your contract, on your thing, so. All right, thank you. Okay, sixth case, 24 BZA 39, Sherman and Linda Stevens. Okay, so welcome to grab a third chair and have a seat and state your name and addresses for us, please.
My name is Linda Stevens, 2037 8th Road, Bourbon.
Okay.
Adam Stevens, 106 South Washington Street, Bourbon, Indiana.
Okay, and you, sir?
Matthew Stevens, 8122 Cedar Road.
Okay. Ty?
All right, the applicant is seeking to split a 5-acre parcel into 2 pieces exceeding the lot density rule. Here's a picture of the property. The procedure for this is the Board of Zoning Appeals reviews and makes the final decision on this case based upon the findings of fact as defined in state statute. For the analysis, the applicant is seeking to subdivide a 5-acre parcel into 2 pieces for their grandchildren. The lot is approximately 350 foot by 650 foot. There are no environmental features that make the property unique. For findings, the public health, safety, and welfare, use and value, and strict application are taken into consideration. For finding number 1, the injurious would, the proposal would not be injurious, wow.
To the public health.
The proposal would not be injurious to the public health, safety, and general welfare. I apologize on writing that one. Finding number 2, the strict application of the ordinance would not be permitted. For finding number 3, the strict application of ordinance would not permit the proposal. For recommendation, based on the information provided and reviewed by staff would recommend denial of the proposal. During TRC recommended approval with the suggestion that the subdivision committee look into these types of subdivisions, but that ended up being a split vote, 1-3, not in favor of the proposal. It was a rather lengthy discussion. There was a lot of agreements that we agree with what they're wanting to do, but the ordinance itself is not permitting that. But it is now up for board determination.
So Ty, this 1 acre thing that you and him are going to talk about here, if they took an acre out of that, they could do it. Is that right? Or
No.
No.
Yes, it's less than,
Huh?
it's too small.
Okay,
You can take an acre out of it if it was 10 acres.
okay, thank you.
How many acres was the first one?
5.
Okay, I'm completely confused, so.
That's why I asked.
Because we could split that 5 acre.
You can do anything with a variance. You can do this with a variance. They got the
Yeah, but we
variance.
set a precedence when we start splitting these. I mean, we have and like I said, I'll have to go through this and have him explain to me why we can do less than 5 acres, because here, we can't do less than 5 acres.
You couldn't do less than 5 acres on the last one. The recommendations were different. First one was recommendation of approval. This one was recommendation of denial.
Okay. Is there anything you guys would like to add, explain what you want to do or anything, or?
Well, yeah, my husband has had cancer. He had a stroke. We can no longer take care of that 5 acres. And we've tried to get the neighbors to help us keep it mowed or keep it tilled. And they've been gracious in helping us do that. But now the neighbors got their equipment stuck, had to have a crane come and pull it out. And we just can't take care of it anymore. And it's overgrown. And we have grandchildren that want to build homes. So we thought, let them take care of it. So we need to start downsizing. So
We used to have crops in there up until 2 years ago. The farmer across the street there would do it, but it got to be too much for a big piece of equipment to go across the road to try to do a little 5 acre lot.
So the 8122, is that where you live?
No.
That's what, I'm
where
the
he-
one on Cedar right there that butts up the north end of the property there.
So
I'm
you
the only
have a house there now?
Yes, I have a house. I'm the only house on Cedar Road between 8th and 9B. I'm the only one on that whole road.
So who's going to get the other two if you split them?
One of my
Grandchildren.
sons and my nephew.
Okay, so it's your kids? Okay.
Yeah,
It's not
my
you
kids,
guys.
it's all family.
Okay.
It'd either be a son of mine and a nephew.
Okay, for some reason, I guess I didn't look this up on GIS beforehand. Who owns the property behind it?
The Woods?
Oh, is
Oh,
it-
no.
no.
That would be our neighbors on 8th Road, Irvin and Ida May Hosteller.
What do they do with that piece?
Just hayfield.
Hey,
So why don't they're not interested in doing yours for a hayfield?
they're Amish. They do it kind of by hand.
They too.
Yeah. They have to hire someone to do theirs.
Yeah,
Because they don't
so-
have the equipment to do it
They
either.
use their hay, that 5 acres that they got is just what they need for their horses and
Where do they live?
on
North?
8th Road. North. You're just missing, just
Yeah,
where their property is.
8th Road is just out of
Because there's
frame.
my property, a pond, then my brother's property, but he has an 8th Road address.
So
right?
you're the brother that lives north?
That's my father that lives north of him.
But he's one wanting to build on one of the properties.
So you're the nephew,
I'm the uncle, she's my mom.
that's grandma.
Across the street is another
Yeah.
Okay, got it.
nephew,
So the pond, who owns the pond?
My father.
his father. You just can't see his house, but he has an 8th Road address. I have a Cedar Road address, which is Cedar that runs right down there. I'm the only house on Cedar with a Cedar address from 8th to 9B.
So what's this A3? What,
A3 is an ag residential zoning district. You can think of basically two places in Marshall County that pretty much have this, which is the stretch of North Michigan, north of Plymouth, up to about Triway, give or take. And then you've got the subdivision down out of Tippecanoe.
you did Rippey's as an A3.
Right, Rippey's would be an A3. But it's not a very common,
Yeah, I'd never heard of it till you did Rippey's, so.
not a very common practice. But no, the property all used to be a part of the same farm. And they've had different sections and chunks come off of it. Ms. Stevens lives just out of frame to the northwest at the intersection of 8th.
She's on the other corner that you can't see.
So if you take Cedar Road north, about as far as 8122 is north and south, you go north of that pond, that distance, that's where 8th Road is.
They're
It's
on one-
just out of
one
frame.
corner. My brother's on the other corner. I'm just south of him. The other nephew's across the street on the other corner of Cedar and 8th.
Okay. Anything else you guys would like to add? Anybody questions here?
I think so.
No?
No.
No? So
Sorry.
Motion open public hearing?
Motion on public hearing.
A second?
I'll second it.
Motion made second, open public hearing. Those in favor say aye.
Aye.
Opposed, nay. Motion carried. Public hearing is now open. Anybody here to speak in favor of their request? Anybody here to speak against? Any correspondence?
I do have a correspondence. It reads, "We are in favor of this variance request, Sherman Stevens Jr. and Wendy Stevens."
Which is you guys.
That's my
No.
father.
Okay.
That would be his father.
Okay. That it?
That's everything I have.
Got a motion to close?
Motion to close.
Have a second?
Second.
Motion made and seconded to close public hearing. Those in favor say aye.
Aye.
Opposed, nay. Motion carried. Public hearing is now closed. After the meeting, we'll have to sit down and talk about but 5 acres is, when this was drawn up, that was the minimum lot size. I don't know how it got changed. We'll find out afterwards, but I don't know. I don't want to veer from it, so.
I'll make the motion to approve the variance.
Okay, do we have a second?
I'll second.
Motion made, seconded. Lori, to approve?
Mr. Bennett?
Yes.
Mr. Kephart?
Yes.
Ms. Maris?
Yes.
Mr. Gustafson?
No. Pass, so you guys are all set.
Thank you.
Thank you.
Okay.
Have a good-
Seventh case,
have a good
24
one.
BZA 40.
I'm still confused on this. We split one in half and then this. I'm confused.
We'll do it after.
Okay.
Seventh case, 24 BZA 40, John Yetzi.
Back again.
Have a seat. State your name and address for the record, please.
John Yutzi, 1899 Beach Road, Napanee, 46550.
Okay, Ty?
So we have a request for a variance development standard to allow a dog kennel with 600 foot within 600 foot of neighbors located at 1899 Beach Road, Napanee, Indiana, German Township, zoned A1. So in August, we had the motion to approve the request for the dog kennel at 1899 Beach Road, Napanee, allowing 17 dogs, seconded and approved 3-0. But it's back before us because of the distance to the neighbors is less than 600 feet to 5 different properties or 5 different structures adjacent. So we're having to get that reduction in order for him to continue that operation. Here's another picture of the property, as well as pictures that were a part of last month's hearing. The procedure for this is the Board of Zoning Appeals reviews and makes the final decision on this case based upon the findings of fact as defined in state statute. For the analysis, the applicant received approval for the dog kennel operation in August, but also needs the setback reduction of 600 foot to neighboring property owners. The setback was not discovered until shortly before the August BZA meeting, so this application was not able to be heard until after the use itself was approved. The nearest residence is to the northeast and is approximately 300 feet from the structure to structure. For finding number 1, the approval should not be injurious to the public health, safety, and general welfare. For finding number 2, the use and value of adjacent property may be affected proportionally to that reduction. For finding number 3, the strict application of the zoning ordinance would not permit the proposal. And for recommendation based on the information provided and reviewed by staff would recommend approval of the reduction provided that the neighbors within said distance do not object. And TRC also gave a recommendation of approval. Now it's up for board determination.
Anything you want to add?
Not really. So I did talk to most of my neighbors around there. John, which is right across the street from me, and I've got signatures from most of them. So the only ones I didn't talk to is the one across the street from me, which he doesn't live there. He's there like once a day to do chores, and that's usually when I'm not at home. So I rarely see him ever. I probably should have made a point to try to catch him when he's there on Saturday and get his signature, but I didn't do that.
Is that where the horse is?
Yeah,
Okay.
like right next door, right across the street from me. He's got a couple horses there.
I see a horse there.
Yeah, he comes out there. We used to be there twice a day, but now he usually comes out once a day usually around lunch, I
It's
think.
not the brick house, a real nice brick house.
No,
It's
the brick
south.
house, I got his approval, and, well, that was a lady, Jolene was here last week.
Okay.
Then I've got the approval from the one just north of me. Then right south of me is a rental house as well. So I don't have a signature from him either.
So can you go back to the picture that has all the distances? So who don't you have?
So I don't have the one that's right south of me there.
2013?
That's the rental property.
2013?
Yeah.
Okay.
Which I didn't talk to, I should have talked to him as well. I'm sure he's fine, or he's never complained. I talked to him. I know him. So we're fine there, I'm positive, but I should have got his signature. Then the one right across the street there, a little to the north there.
1842 or 1905?
Oh, that should be the 1905, I guess. Isn't that my address? No?
The 1905 would be his.
Those are mine.
On the west side.
He might not even have an address there, I guess. He's just got a little barn there.
Okay.
That's the one I don't have. I've got the brick
There's no
house.
there? It's just a barn? on
No,
the
just a
property?
barn. He comes and does his chores once a,
All right, that's, I didn't remember seeing a house there, so.
yeah.
So
Then
the kennel's
Sorry.
already built, right?
yeah. the kennel, everything's approved. So I know you weren't here last time.
I was not.
So that's kind of the whole, there was an existing chicken barn there and I redid it and I didn't realize, or I should have had gotten the permits and everything before that, the variance, so that's why I'm trying to correct everything. So that's the whole,
That cleared it up.
okay.
And they didn't realize, I don't know, somehow got mixed up about the 600 foot and it didn't get advertised, so we had to come back this month.
So I think that's all I have.
Okay.
Motion, we open it up, public hearing.
Second.
Motion made by Jim, seconded by Trent, to open public hearing. Those in favor say aye.
Aye.
Opposed, nay. Motion carried, public hearing is now open. Anybody here to speak in favor of his request? Did you want to speak in favor? No? Okay. Anybody here to speak against? Any correspondence?
I have a letter and then a signature list provided. First one is to the members of the Board of Zoning Appeals. I'm currently out of town and won't be back in time to attend Tuesday, September 10th meeting. I'm writing in regard to John Utzi's request for a variance in zoning to accommodate a dog kennel he owns. His kennel is within 300 feet of my house, which is far less than the current legal allowable distance of 600 feet. At a previous board meeting, Mr. Utzi stated, one, he raises a specialty breed of dog, which seldom ends up in shelters or rescues. He states he is working to improve his breed's bloodlines and is responsible in his breeding practices. The position of our County Humane Society was that we do not need another dog kennel. Our rescues and humane societies are shamefully overflowing. Our area's puppy mills are major contributors to this horrible situation. Mr. Utzi states he does not intend to be part of this problem. Two, he has promised to rearrange his outdoor kennel runs where the dog's barking is not disruptive without denying his dog's access to outside exercise. Three, he states that he has a plan in place for neutering and rehoming his retired breeding dogs and is currently following that plan. The pictures of his kennel appear clean and seem to provide good care for his dogs. Anyone with means can build a beautiful kennel, but it takes an ethical person who puts in the welfare of his animals above financial gain to deserve the board's approval to operate one. I would only support a conditional approval of this variance by our planning commission based on his stated current and future business practices. One, raising only this breed. Two, he continues to keep the dogs in clean, adequate conditions with good medical care. Three, the dogs are allowed outside exercise without becoming a barking nuisance. And four, his retired breeders are neutered and rehomed. Four, the local Humane Society has allowed access to his kennel without prior warning, a planning commission requirement. If any of these conditions change, I would ask that the county stop his ability to operate this kennel immediately and enforce their decision with legal action. Mr. Utzi has already shown his disregard for our existing laws by building this kennel facility without a building permit and operating a kennel without the proper legal variances. Harlan Kennel LLC was established March 22 of 2021. Respectfully, Jolene Benz. And then the second, pardon?
Was that?
What address was that? Is that one of the? homes?
1842.
That's the break,
The one northeast.
right?
That's the lady that was here last time?
And then I have a paper provided that says, I agree to the location of John Utzi's dog kennel at 1899 Beach Road with signatures from John and Jolene Benz, Laverne and Rose Utzi, Lyle and Linda Hostetler, and Nate Miller. The adjacent neighbors, we found Benz, Utzi, and Hostetler. Which one's Nate Miller?
So, yeah, some reason I was thinking he was in there as well. He's just from Lyle Linda Hostetler. He's just south. Like they're
Just
right,
south?
right next door there.
So can you click on 2030?
Look, there's a shop and there's a house right there as well.
2030, one east. Yeah, what's that?
Because the 2030 address is that shop, or the house they redid?
Yeah.
Is that
the
the-
new house that's Nate.
Okay.
That's Nate.
Yeah.
Is the brick house that was torn down and redid?
Yeah.
Okay.
Yeah.
Okay, so Nate would be the 2030 address.
'Cause we get a variance.
It's pulled under AMMF,
Oh.
so we can't see
okay. Yeah.
that
would
portion,
be-
but everybody else is easily found within Beacon's system. That's everything I have.
So two, we don't really have They didn't
Would be the
respond?
barn east and the property owner south, correct? Mr. Yotzi?
Yes.
Okay. That's all the records I have on my end.
Okay, do I have a motion to close?
I'll make a motion to close.
Second.
Motion made and seconded to close public hearing. Those in favor say aye.
Aye.
Opposed, nay. Motion carried. Public hearing is now closed. I drove by there today. So the lady that wrote the long letter was the one that was here last time, right?
Correct.
That spoke really good about him.
Yes.
Okay, and it kind of seemed like she was.
Yeah, that letter, I
It
was
was-
confused. Was that support or not?
It's supportive of what he's doing exactly, as long as he's
But
above board. Because it's the same
Maybe
thing
I'm
I
not
remember
allowed to
being
speak.
supportive.
Yeah,
So the letter.
She wanted to see the dogs. She didn't want him to put something up. She liked to see him out there and the kids playing with the dogs.
She
When I
was
talk-
supportive of it, but she wants to make sure he's going
The
and
5 things she
doing
said
what he's.
are the 5 things that I require, and,
if basically what she's saying, if I ever change,
okay.
then she would like for you to say, hey, I'm not allowed to do this anymore. That's the way I take the letter.
Correct.
And I just talked to her husband today, and he said, well, I talked to him about privacy fence as well. And he said he doesn't hear him. He said, she said, I've got hearing aids. And I talked to him about a privacy fence. He said, no, I like to see him run out there. He said, don't put a privacy fence up. So I guess, that was him talking, which last time she said the same thing as well.
Because you've got horses in the first paddock.
Right.
And then the dogs, and then horses again. And,
Right.
I mean, the place is immaculate. I didn't pull in or anything. I drove by there today, and it's immaculate, so.
How many dogs?
Like I'm approved for 17 right now,
17, okay.
like 15 females and 2 males. That's what I'm approved for right now.
Okay.
That's not what I have.
Okay, but we're just doing the
The
600
variance.
foot.
Yeah.
Okay,
I do have some questions.
go ahead.
Just for my own edification. The restrictions or the things that she would like us to add, is that something that there's another governing body that would oversight, or is that strictly something that, it just seems like it's, those restrictions on, for us in a motion, is that,
She would like to see them as conditions of your motion.
okay? But there's no other governing body out there that,
Weren't they conditions of what we did last month?
I think we just did number of dogs. We didn't condition him to breed or, if he wanted to change and do dachshunds.
My letter that I got from you guys said I am approved for 17 dogs. That's what my letter didn't, like, I have applied.
There wasn't a list of conditions
No,
associated
there
with
wasn't.
that.
There was just,
Lots of times we will do conditions. It'll say
yeah, I
signage
know
of a
we do
certain
some
size. and-
conditions, but that just seemed to go into, seems like a different.
Because I got my list of the 5
Basket.
things that has to be done, but this one, the number 1 was Nancy Cox has to approve it, but she wasn't here, didn't reply or anything, so, but.
which I'd have, everything would be USDA certified, so I've got my regulations there, which would include some of the stuff that she's asking for. And if I don't abide by that stuff, then which, technically, I guess, I'm not planning on it, but if I wouldn't be if I'm USDA certified, that, like, those conditions are, I guess to make it easier, you could be put in there that I have to be USDA certified. That would, like, take care of
The
that.
big thing that I want is Ty or Nancy can stop in there anytime and see what you got, without having to have prior notice,
And that's already within the zoning ordinance.
okay?
Oh, it is?
And
Yes.
everything is the vet records and stuff like that, but that's more for the pug-nosed dogs, because those have to be taken out.
I still have, I'd have all my vet records as far as when they see the vet, what vaccinations they get and all that good stuff. And then all the stuff that I administer that I have to keep track of,
Okay.
like when I clip their nails or clean their ears and all that stuff.
Okay.
I'd make a motion to reduce, to approve the variance to reduce the required setbacks for the kennels.
Do I have a second?
I'll second.
Motion made and seconded to approve. Lori?
Mr. Bennett?
Yes.
Mr. Caphart?
Yes.
Ms. Mears?
Yes.
Mr. Gustafson?
Yes. Okay.
Next time you should have put my case first.
Then you would miss all the fun. Is
Is that it?
Do you have any other?
That's
business?
everything this evening. Next meeting is October 8th.
I have one thing that you weren't here last month. It's a July meeting. At the fair, and it was a long meeting, and I was really tired. So I asked if, when you make the schedule out for next year, if you would move the July meeting to the 15th instead of the 8th.
Oh,
Be
push
one
it,
week-
push it
later.
1 week to the third Tuesday?
Pardon me?
Push it to the third Tuesday?
Yeah, right.
Okay.
I know you're going to make
Same
it
time every year? The-
up. Well, I don't know. That's the date of the show.
Okay, they
I'm
already
up
have
at 4
that
o'clock in
set.
the
They already
morning,
have that set.
and I was here till
just wanted-
midnight that night, and it
So for
was.
2025, outside of November and December's calendar, you'd want to take July into consideration as well
So
to
instead of July 8th, July 15th.
assist in avoiding the fair.
I've never missed a meeting in the years that I've been on here, so I would like to not miss a meeting, so.
Okay. We
I would
can,
like to not go through what we went through.
we'll get that proposed
I know it's coming up. here.
October, November.
Okay, I just asked.
There's
probably
5
get that proposed in
Tuesdays in
November.
July, so
Yeah,
there's an extra Tuesday in there.
and that's all I've got. Do I have a motion to adjourn? Do
I motion to adjourn.
I have a second?
Second.
Motion made, seconded to adjourn. Those in favor say aye. Aye. Opposed, nay. Motion carried. We're adjourned.